Don't forget to switch off the cell phones there, please.
Interpret. No?
They want the post-original content.
Floyd. Sorry, I don't see the TV. Just so you know, so just a few cutaways of
Yes, I saw that. It's come down morning, sorry, just showed me the problem with the dispense. So I know that you might not be speaking a lot, but you may be speaking on tape, and I'm not willing to take the risk. So it's about, they made a lordship here. And they will also see from internal view, will see if you cannot just prepare. So it might be a 10-15 minute thing.
This man of the band of Kanshipur. The man of the band of Kanshipur. What is the having cause of
It's fixed.
It's fixed?
Yeah.
It's fixed.
It's what the
But it's fixed.
Oh, okay. All right, okay. Come on, okay.
He said there's only one to switch the it's okay, one mic. There's one mic that's not.
Oh, one mic.
Yeah.
So we want to fix that.
Yeah.
Okay, so
It will be 5 to 10 minutes.
This line is not an issue. Mike. Hook. Luis el otro. Solo for cameras as well. Show me hairstyle, yeah. Show me hairstyle, yeah. 056. La foto na la foto na yeah, just how bullet for mona the conta foto ya
Extrema point. I'm down now. I'll be up before. I'll let try
Tena ingekuwa kama
We're starting.
Mike am always on the listen. So better way.
Possible power station.
No. Kata kama kisanda. When are they going? Yes. Thank you. Kosovo. You've got a new team up with you.
Yes.
I can see.
Since yesterday,
Yo, I condone você tem que fazer novo. É paga. Antoinette dong orang aja kena. Antoinette.
No need for it, I'm going to say it loud, so no need to shine the flash in my face. Please.
That's all.
Please, just you may take a seat just for a minute. Sorry, in all the rush and all the microphones and everything, I've just left my notes that he's fetching. It will be a minute, then we will proceed. We'll go on record. We may go on record.
Thank you, Worship. The date is the 19th of October 2023. Case numbers Regional Court 44620B, State versus Julius Malema and Adriaan Snyman. Parties are the same as before. Presiding officer Mrs. T. Olivier, Public Prosecutor Advocate J. Caesar, for the defense Advocate Otis for accused number 1. Advocate Matthews appears for accused number 2. We wish, however, Ms. Cullis will be standing in as arranged previously for Advocate Matthews. The clerk is Ms. Madonna. Wish the matter was set down today for the judgment on the Section 174 application made by the accused. Thank you.
Thank you. Advocate Otis, on behalf of accused 1, ready to proceed. Thank you. Advocate Collins, Ms. Collins. Thank you. As stated then, for the duration of the ruling, accused 1 and 2, please remain seated. There's no need to stand for such an extended period. The court will proceed with judgment in terms of Section 174 of Act 51 of 1977, as brought by Advocate Odes in respect of Mr. Malema as far as it pertains to counts 1, 2, 3, 5, and 6. And with regards to accused 2, the application brought by Advocate Odes in respect of counts 4 and 6. I want to start off by saying that I thank the state, the defense, Advocate Odes, and whoever assisted. Advocate Matthews is not present, therefore Advocate Collins. They have indeed, and I want to place that fully on record, discussed all the relevant case law in their heads of argument, but it would have been a tedious exercise since we all use the same case law for the state to repeat exactly the same cases but possibly extract different paragraphs. Same will be used by Advocate Odes with referring to others, and same applies to accused number 2 with regards to that aspect. So I just want to make sure that all of those cases were discussed fully in their heads. However, it is the duty of the court to start such proceedings off by, in fact, now placing the contents of such cases on record. Okay. Therefore, Section 174 of the CPA 51 of 1977 provides as follows. If at the close of the case of the prosecution at any trial, the court is of the opinion that there is no evidence that the accused committed the offense referred to in the charge or any other offense of which he or she may be convicted on the charge, it may return a verdict of not guilty. In the matter before court, the state and the defense that being Advocate Caesar, Advocate Hodes and Advocate Matthews addressed the court fully in their heads of argument and as already stated with reference to the relevant case law. Therefore, I am not going to repeat the heads raised in the documents one by one, but will respond to them during the proceedings. The procedure provided for in Section 174 of the Criminal Procedure Act of 51 of 1977 is nothing new, and both the predecessors of the current Act contained similar provisions. It is trite that the words "no evidence" do not mean no evidence at all, but rather no evidence on which a reasonable court acting carefully may convict. The case law with regards to the said application is clear and precise, so as to guide any court faced with the said application. I will briefly, in chronological or date order, place the following cases and reference on record. It starts with R versus Shane, 1925 AD 6, followed by R versus Harold and others, 1956 2 SA 722 Witwatersrand, S versus Mteta and others, 1983 4 SA 119 capital D, State versus Shooping and others, 1992 2 SACR 544 in brackets V. Also State versus Puravata, 2001 2 SACR 603 in brackets SCA decision, and followed by S versus Lubatra, 2001 2 SACR 603 brackets Supreme Court of Appeal decision. In one of the latest decisions of the Supreme Court of Appeal in State versus Doorewaard, 2021 1 SACR 235 SCA, it was confirmed that the failure to discharge an accused at the end of the state case, where there is no credible evidence against the accused, conflicts with his right to remain silent and innocence. Whether or not the refusal to grant discharge entails the exercise of a discretion by the trial court, and that it may return a verdict of not guilty and discharge the accused there and then, or it may refuse to discharge the accused and thereby placing him on his defense, was considered in the case law. In State versus Shooping, the citation already placed on record, including that of State versus Lubatra, citation placed on record, states in essence the rule in Section 174 of Act 51 of 1977 caters for the pre-trial, namely the presumption of innocence on the part of an accused until proven guilty, and his or her right to silence. It further puts an abrupt end to the case which has no prospect of being successful in circumstances where the evidence falls abysmally short in proving even a prima facie case against an accused, thus ensuring the valuable court time is not wasted and unnecessary expenses not incurred. It should be mentioned that the evaluation of the evidence at this stage of the proceedings differs from that at the end of the trial. It is therefore a sui generis interlocutory procedure. The test must be applied with judicial discretion on the specific facts and circumstances of each case. The preferred process of law and the compass on which this matter should be adjudicated, including the relevant test, is simplistically put, and in my view, a combination of the first leg of the Shooping case and the dictum in the Lubatra case, and the principles of a fair trial in terms of the Constitution of South Africa 1996. The manner in which this discretion must be exercised has been considered in several decisions. It is evident that the presumption of It is evident that the presumption in favor of innocence, the fact that the onus rests on the state, as well as the dictates of justice, will normally require an exercise of the discretion under 174 in favor of the accused person, where the state case is virtually non-existent. Strengthening or supplementation of a non-existent case is in any event a physical impossibility. Finally, the court will refer to State versus Ndlanga Mandla and another, 1999, 1 SACR 391 in brackets WAD bracket, where Willis J. considered the application in terms of section 174 and held that amongst other factors that credibility, where it is of such poor quality that no reasonable person could possibly accept it, should be taken into account at this stage. This approach was followed in various matters that followed, including State versus Mtembu and others, 2011, 2 SACR 286, as well as in State versus Agliotti, 2011, 2 SACR 437, brackets GSJ, bracket, and the locus classicus in considering the relevant section, including the constitutional implications, which was clarified in State versus Lubaka, decision and citation already placed on record. Lastly, with regards to the various case law, the court needs to refer to the position in as far as it relates to more than one accused person, as well as it is the position in this case today. Whether or not and in what circumstances the trial court should discharge an accused who might be incriminated by a co-accused is not a question to be answered in the abstract, for the circumstances in which the question arises are varied. The court once again refers to the matter of Ndlanga Mandla and another, where it was stated, I quote, "In my view, a further relevant factor is that the accused's right at the outset gave an explanation of plea, i.e. accused 2 denied the allegations and placed emphasis on the fact that he did not hand any firearm to his co-accused, being accused 1, and accused 1 had from the outset denied all allegations against him. Therefore, in causa, the cross-examination on behalf of accused 1 and 2, together with the absence of conflict between accused 1 and 2, as well as the content of their respective plea explanations, clearly indicate that accused 1 and 2 will not incriminate one another in this matter. In this regard, the court also refers to the request for further particulars by Advocate Matthews on behalf of accused 2 and the state's reply thereto, also mentioned in the heads of argument on behalf of accused 2, which we will still deal with. Lastly, with regards to the credibility of the witnesses and the application of 174, it was not always considered to be a relevant factor in the past. However, it has developed in the later years from not only being taken into account but also becoming a relevant factor. The sentiment was shared and expanded on in State versus Agliotti and also applied in State versus Diwani, citation in brackets CC15/2014, and pronounced more explicitly in the Doorewaard case, citation already on record. The court is given the power to render there and then, at the closure of the state case, a judgment of not guilty. There is, however, a jurisdictional prerequisite to be satisfied before the power arises in this manner. The court must be of the view that there is no evidence upon which a conviction can be based. Therefore, 2 related but distinguishable decisions have to be made.
Firstly, is there a lack of evidence, and if so, should discharge be granted? The former entails mainly a clinical assessment of the evidential value of the evidence. The latter requires sound judgment in the light of all circumstances of the particular case. Therefore, there is no obligation to grant a discharge, but there is indeed a competence to do so. The state, including the defense for accused 1 and 2, had indeed referred to all the above quoted cases as I've stated. I will now start off firstly by outlining the evidence presented by the state to court at this stage, whereafter I will deal with the heads of argument raised. Okay. It is indeed so, as pointed out by state and defense, that 19 witnesses in this matter was called, and the state during its reply and the defense in its application had also during the 174 read out all 6 counts or charges as far it relates to each accused. Therefore, there is really no need to repeat the charges as they are already on record and was repeated in the heads of argument. The court will now proceed with the evidence presented by the state thus far. Firstly, the evidence of Colonel Nkwali was heard, who was appointed on the 4th of July 2018 as an authorized member of the upcoming EFF celebrations to be held at Sishe Dukashe Stadium on 28 July 2018. His duties entailed calling of security meetings with all relevant stakeholders, including representatives from the EFF itself. However, on the 28th of July 2018, the EFF was also represented at the prep meeting by one Mr. Dlamini. The duty of the witness was to ensure a safe and incident-free event. He testified that a decision was made that no weapons in any form may be allowed except for those assigned as protectors for the leadership. Testified that after the event he was phoned by Brigadier Nkoho on 1st of August 2018 and he was shown a clip which depicted a white male handing a firearm to be now known, or according to the evidence of this witness, Mr. Malema, who started firing shots. He was also the complainant instructed to open a case in this regard, and further that only the EFF security was allowed to regulate who will be allowed on the stage during the event. He also confirmed that he had not received any reports of any shooting during or before or after the event. This is in short a brief summary of the evidence. Evidence of Ms. Makoma was heard, an employee by BCM as a general contract worker. She was present on the day of the incident performing duties and also present on 30 July 2018 for clean-up duties of the stadium. She testified she picked up a large cartridge case, called a friend Pumeza to have a look, and it was handed to her supervisor, who told her to place it in a drawer of her office. She confirmed the photo depicted in Exhibit A shown to her as the cartridge picked up by her, and further that she had pointed out to the police where she had picked up the cartridge. She further deposed of a statement. Ms. Nomfundo Luana, employed by BCM and the supervisor of the general workers, she was also present on 30 July 2018. and confirmed that a cartridge was brought to her and confirmed the photo depicted in Exhibit A1 shown to her. Police arrived and she handed the cartridge to the police officer. Jonathan Kumalu, an assistant manager of disaster management, who was also present on 28 July 2018 and issued a structural clearance certificate. He was also on duty on 30 July 2018 for a post-event inspection and was called by the general worker who picked up dirt and responsible for cleaning the field, and he was shown a cartridge. He took the cartridge and a photo thereof and confirmed the photo he took as being that of Exhibit A1. Captain Johannes Swart, attached at the time to the Mtansane Detective Unit, was requested to visit Sisa Dukashe Stadium on 1 August 2018, and on his arrival he was given the said cartridge by a BCM supervisor, which he placed in a sealed evidence bag. Testified it was, according to his knowledge, a rifle cartridge. Mr. S. Thunder, the regional manager of SERA, Private Security Industry Regulating Authority, who was requested to assess the profiles of two security officers, one Mr. Larry Mabundla and Mr. Snyman. Needless to say, it is contained in his report that there were no irregularities regarding their access or profile that he had accessed. Captain Govender, now retired, however, the provincial spokesperson on behalf of SABC and at the time, testified she received a WhatsApp on the coordinator's WhatsApp group. It was a video with a message attached inquiring as to whether there was any particular office where this incident had occurred. The incident was in fact the EFF celebration. The video, according to her evidence, depicted a male firing shots and walking towards a male and then turning around and walking back again. She forwarded the video via WhatsApp just as she received it to Captain Mzuko, the cluster communication officer of SABC and also responsible for the Mtansane cluster. She described the male who fired the shots as a huge political leader at the time and still is, and was in fact accused one, Mr. Malema. She testified she did not tamper with the footage and sent it just as she received it. The footage was played or shown to the witness, who confirmed in court that indeed it was the video clip she had received, and also confirmed it was the clip she had sent to Captain Mzungu. Captain Mzungu testified he received a video clip from Captain Govender on 1 August 2018. The video depicted Mr. Malema and Mr. Snyman and shows Mr. Malema shooting a firearm, after which he handed the firearm to Mr. Snyman. He informed the station commander and also sent the video to the cell phone of Colonel Swartboy. It was decided that an inquiry must be conducted. Therefore, a docket had to be registered, being Mtansane Cas 06/08 of 2018. He also viewed the footage in court and confirmed that it was indeed the video clip that he received from Captain Govender, and also that it was the very same video that he sent to Colonel Swartboy. He, however, conceded that he is unable to identify the firearm in the video, safe to say that it was a rifle. Lieutenant Colonel David Jansen, based at Durban Firearm Unit, his evidence is read with the report he had compiled, being Exhibit J, testified he visited the Tactical Security Office in Durban to conduct a compliance inspection. His findings is depicted in Exhibit J, and all the registers were found to be in order, save for the firearms that had been booked out to other officers. that being 30 firearms outstanding, and he confirmed that the firearm mentioned in column 6 or number 6 was brought, no, not number 6, let me rectify that, sorry, confirmed that on 6 August 2018, whilst he was still at the offices of the Tactical Security Company, one Mr. Larry Mavundla entered, and the firearm SPA 249, including a 9mm Glock, was handed to him and entered into the register. Accused number 2 was present at the time. Sarl Kruger, a captain at Brixton, no, that should be Brighton Beach, KZN, received the 3 batches of firearms and handled the safekeeping thereof and the return of the batches of firearms to Mr. Snyman. There was also the evidence of Dwayne Francis, a sergeant at the Directorate Crime and Forensic Investigations and Digital Science. His evidence is accompanied by Exhibit H and was requested to download footage from the phone of Colonel Swartboy, which he downloaded on forensic software at the office. Thereafter, the footage was downloaded on a verbatim CD and sealed in an evidence bag and handed to Captain Botha for further analysis. He had confirmed the clips were indeed downloaded from the phone of Colonel Swartboy under the application WhatsApp. He further explained that all footage was downloaded on the forensic software, whereafter he was directed by Colonel Swartboy to download 2 clips, which was then downloaded on 2 verbatim CDs and placed in a sealed exhibit bag. Philip Becker, a warrant officer stationed in PE as a crime scene investigator, confirms he received a request to process a single cartridge and found that the cartridge was not linked by fingerprint or touch DNA to any of the relevant persons. It is depicted in the photo album that was compiled. Further photos 1 to 6 up to 131 depicts a firearm he investigated. Photo 1 to 9 shows the serial number of the firearm CN SPR 249/14. He was also asked to record a video of I would call a shooting simulation of the muzzle flash test. It was done during a shooting simulation indoors. A video was compiled and thereafter it was downloaded to capture still photos of each of the shots fired. Measurements were also taken by him at Sisa Dukasha Stadium, where the various positions were pointed out to him. The measurements were done with an handheld sensitivity device, which he downloaded the data onto a Garmin street map and Google Satellite Street program. The satellite images depicts point A and B, A being the podium and B the spot where the cartridge was picked up, and the distance between A and B estimated plus minus 23 meters. It was followed by the evidence of Amanda Steenkamp, a qualified facial identification specialist, and her evidence further was corroborated by the report submitted as Exhibit J before court. She testified that the first request she received was to conduct a facial comparison, facial review, and a facial examination. Sorry, just a minute. I've done it. Her findings per page 7 and 12 of Annexure A was positive in that the general class characteristics and the presence of individual identifying unique characteristics that were found During the analysis between the person in the CCTV images is found to be the persons depicted in the CCTV images and in the control photos. It is therefore found that the persons in the CCTV images and in the control images depicts the same persons. The evidence was followed by that of Colonel Mandisa Mgwadleka, attached to the ballistic unit in Port Elizabeth. I will give a brief finding made by this witness, as it is appropriate in this instance only. In a detailed report, his findings were in short that the cartridge case in question, compared to the individual class characteristics markings and individual characteristic markings transferred to them by firearm components during the firing process using a comparison microscope, and found that the cartridge case mentioned was fired in the firearm in question, that being PSA 24914. It leaves us then with the evidence of Colonel Swartboy. In that regard, I will merely refer and state that he had given an explanation of the investigation he had embarked on from receiving the information up to the date that he had testified in court. The court further needs to place on record that there was also employees of Gear House based in KwaZulu-Natal who had testified, who was present during the time of the incident of the celebrations. The witnesses being Mr. Ashley Singh, Mr. Samuel Kwata, and Sibusiso Ngobo. Now, Mr. Singh, being the branch manager employed at Gear House Company, was not present during the celebrations, but confirmed that they had provided audio-visual support to the EFF on 28 July 2018. He confirmed that on the 3rd of August 2018, he was contacted by Brigadier Governor stating that they are investigating a matter and need to physically inspect their stage. He told him that the stage will have to be reconstructed and stated that he needed to do an inspection to see if they had suffered any damages due to the shooting incident. It is clear that his evidence led to that there was no damage found on any of their equipment, including the sails used. He confirmed that the entire event was recorded. He also confirmed that he had viewed the footage being video 1 and 2 shown to the witness. He confirmed that what he is viewing was indeed the footage downloaded from the hard drive of the laptop and was then provided to SABC at a later stage. He had requested the footage from audio-visual department. He cannot identify the person firing the firearm. That is as far as his evidence will take us. Was followed by that of Mr. Samuel Quata, the AV technician on duty on 28 July 2018 and contracted to work in East London for the celebration of the EFF's 5th birthday event. He is a senior AV equipment and technician. He was also part of the people who had installed the cameras. He installed 2 cameras on the left side of the stage and he used the right side and one in front. The accused testified that he had seen accused 1 delivering his speech. He did not see or notice any shooting incidents during the event. He heard about it the following day as a male that he was working with had a clip on his phone and he saw dancing, singing of struggle songs and a gunshot fired. He did not see who was shooting. He was visited by SABC at KZN office and called to install the footage from a machine they used onto a hard drive. There was no tampering with this evidence and the video clip, 3 video clips shown to the witness which he had confirmed as the footage recorded and downloaded. The witness Sibusise Ngobo, also employed at Gearhouse Company in KZN, an audio-visual technician, also on duty 28/7/2018. He had also taken part in setting up of the cameras on behalf of Gearhouse. The entire event was recorded. He confirms that everything that happened on that day was recorded. He confirms he saw accused 1 as he was the speaker, and though he does not know accused 2, he saw him there as well. He did not observe or see any shooting incident on the 28th of July 2018. Once after the event, once he had finished recording, he double checks to see that the recording is indeed there on his laptop and as well as on the hard drive which he was recording on. He would browse through it and also check that there was audio and no glitches. He then submits the hand drive and to the project manager who is on site from Gearhouse. He did this on the 28th of July as per procedure. Days later, he was visited by the NPA and Hawks at Gearhouse in KZN and asked to join them in a meeting to discuss this event. He had confirmed that to the Hawks that he was indeed the person who had recorded the events on that specific evening, and he was asked if it was the original video and what process he followed. It was explained and it stated there was no tampering with any of the footage. The hard drive was then handed to Gearhouse project manager based in Gauteng. The first and second video was played to the witness in court. The witness confirmed it was the videos from the 2 cameras angles he was mixing. The first video he had seen before. The second video was his first time to see that. The second video he viewed. Confirmed that the footage provided by Gearhouse to the Hawks is correct footage. That is as far as the employees of the gear house. Sorry to do this. May I inquire what the time is currently, please? 10. Okay. I'm sorry, as you saw, I asked for my whole notes to be brought, but there's 3 pages missing. I need a minute to grab it and run right back. Okay, sorry. It is in the printer, I'm very sure. Sorry for that. I'll be right back. Go through these pages.
One for the slides, That one. No.
Therefore, we are back on record for resumption of RC 446/2020B. Everyone's still ready for me to proceed? Thank you. To look at the heads while answering, I will have to page as well. In reply to Advocate Hodes, firstly with regards to paragraph 5, with regards to what is termed to be, I quote, the viral footage, and then thereafter the recorded footage detailed by employees of Gearhouse, the Gearhouse footage. It stated in paragraph 5 that Gearhouse depicts the it witness paragraph that for every refers to witness fear of danger that they were attendee from the many people who had attended the celebration was called to testify as an eyewitness. Those are indeed factors which may be relevant at some point in time. At this stage, none of these factors listed in 7 up to 7.4 are requirements for the charges that you are facing, Mr. Malema. It's not a requirement, it does not form part of the elements. In addition, with regards to 7.5, it is where Advocate Hodes raises the 5 SABC VIP Protection Services members. On that issue, the state has a lot to say, but it is not the appropriate time to do so. I will emphasize that indeed, in the heads, it's correctly stated that indeed Colonel Swartboy was only confronted with this aspect during cross-examination by Advocate Hodes. And in fairness, he cannot answer to the contents of those statements deposed by the 3 persons in Gauteng. Those statements were not obtained by him. It was obtained by then Brigadier, now General Governor. I'm not going to even tread on the path of the further question or statement posed by Advocate Matthews that whether he was aware that Minister Bheki Cele had to report the progress to Mr. Malema. That was not within his knowledge. Furthermore, these 5 witnesses is not evidence before court. The contents of their statements, merely to say they stated they did not witness a shooting, does not give me a full picture of what took place as to where they were. Only they could tell, and why they were not called, I find myself wondering since the day I heard so. I notice in 7.6 that they have indeed been traced as pointed out by Advocate Odes. Now with regards to 7.7, the place where the cartridge had been found would have been underneath structures that had been there at the time of the celebration, and stated it impossible for it to have been fired from a firearm during the celebration unless they had penetrated and damaged, and they had not. Indeed so. However, the state did not allege during the state's case that the place or the spot where the cartridge was picked up was in fact the exact spot where the cartridge was ejected. Therefore, exactly as it states in 7.8, it was not possible to say when the spent cartridge had been placed there, meaning or found its place to the spot where it was found. It's not possible for the spent cartridge to have been ejected from a firearm on the stage at the celebration and land where it was found. The state never alleged during its evidence that it landed on the place where it was found. I think it was all in agreement that it had a range of 1.5 and 2.5 meters to the right and to the back. To add to that, the specific request was also to fire up into the air. 7.10, there was no DNA or fingerprints attached to accused one. That is indeed so. I would have been surprised if there was in fact fingerprints or DNA after some time. With regards to paragraph 8, and the evidence of Colonel Swartboy, as explained, there are indeed aspects that is concerning. He indeed gave a precise recount of his investigation during the matter. However, during cross-examination by Advocate Odes, and he stated, I accept, clarification was not sought by the state, and I cannot draw, I don't know what he in fact accepted during his cross-examination. However, it does not take away the evidence that is placed on record by him at this point. I've dealt with the VIP close protection units, and as far as it relates to his evidence already. With regards to 8.4 and the creation of the reconstruction and Sergeant Becker's evidence, as well as the CD made from the viral footage, the court had dealt with that aspect by placing the evidence presented by court on record up to that stage. So I think I have replied to those paragraphs. The fact that accused 2, as mentioned in Advocate Odes' application, that accused 2 fully cooperated and assisted throughout the process. Rifles were received in 3 batches. That is indeed the case. I have also dealt with that during the evidence that was placed on record so far as presented to court. I do concede that under paragraph 9.4, Colonel Swartboy had indeed confirmed that he had seen the statements by the 5 close protectors, but the contents thereof is still not before court. He confirmed had they seen a crime being committed, they were duty bound to report it. We are again 9495 deals with the DNA and fingerprints. I have already addressed that issue. That includes the powder residue tests, which were negative. And then 9.8 refers to no one complained about the conduct at the celebration, no eyewitnesses. I have replied to that. It is indeed so that the photographer of the viral footage was confirmed he had not traced the source, and that the chain of custody then only began when the CD was created. What 9.14, the item that he had referred to as being what appeared to be a firearm, could not be identified through enhancement and still photos. That is indeed the position. However, keeping in mind that the evidence and the cross-examination with regards to accused one and the firing and the muzzle flash, etc., was that you had indeed fired what was called a movie or TV firearm, which also creates a muzzle flash. I keep that in mind. Accordingly also, Colonel Swartboy could not deny that a stage gun or a blank gun may emit muzzle flash. .3 I have answered to by referring to the evidence led, that is that accused number 1 is alleged to have fired a .223 Norinco firearm. So to state that the state had not led any evidence in that regard is not correct. The same accounts for 10.4 and 10.5, and most certainly the court agrees that accused 1 is not required to give evidence to supplement the state's case. I will move on to the heads of Advocate Matthews as far as it pertains to accused number 2. In this regard, accused number 2, the same applies. And I will try to summarize the whole version and cross-examination as placed before all witnesses and in the heads and addressed by Advocate Matthews. It comes down to the fact that count 4 and count 6 remains a statutory offence. It was confirmed in the evidence so far presented by the state that the firearm in question, being the SPA 249/14, is indeed your firearm, or the company's firearm, if I should put it in that manner. The cartridge that was picked up at the scene or close to the stage or after the incident is linked with microscopic ballistic analysis to the SPA 249/14 firearm. much emphasis was placed on the fact that none of the videos or witnesses testified that they saw you handing a firearm to Mr. Malema. But that is not the charge. The charge is, and I will read for clarity, it's much wider. It is to unlawfully supply or in any other manner give possession of a firearm or ammunition, being the Norinco firearm and a Remington bullet, to accused one. So the actual not seeing of handing over is not a requirement in terms of count 6. It is supplying or in other manner give possession. Therefore, accused 1 and 2, you may stand up, please. At this stage of the proceedings, I think the court has placed the evidence so far presented by the state on record. I have in the evidence clarified the issues and heads raised. I've tried to give reasons for the decision that I'm about to pronounce, and to add whether it is correct or not in respect of accused 1, a mere say so that it was a movie gun does not make it so. It's not evidence, the mere say so, in the light of the evidence that has been presented so far. I'm not saying which has been accepted as facts, but which has been presented so far. So in that light, accused 1 and 2, number 1 in respect of counts 1, 2, 3 and 5, accused 2 in respect of count 4 and 6, the application for discharge in terms of section 174 of Act 51 of 1977 is not granted.
The court pleases.
You may please be seated.
I think that is a role for this particular court.
No, there's no, it's not yet. Maybe you want to run. Yes, I want to say in open court so that we all are on the same page. The only reason that I am of the view that dates, I personally prefer to discuss it in chambers. I will provide the defense with subsequent dates to also see whether it suits the schedules of accused 1 and 2. Because my diary contains names and certain dates which I don't think is fair to be placed on media as to which cases and which people I will be dealing with, and I think the same accounts for the whereabouts of the defense. For that reason only, I do not want to do that on media or television or even social media. Okay. In order with that?
Yes.
All right. I assume you will follow in a few minutes, 10 minutes or so after you've had it. Sorry? Court will adjourn.
Sorry about that.